Hello, this is Muhammed Riyas from LegalStanley. Today, let us discuss about certain pitfalls or oversights which the startups make while incorporating their company in India. The first oversight, rather pitfall, which is noted while promoters incorporate a private limited company is with regard to the Memorandum of Association and Articles of Association. We know the Memorandum of Association and Articles of Association are crucial documents when incorporating a private limited company. It is told that Articles of Association are the bylaws and the Memorandum of Association are the guiding laws. So while drafting these documents, utmost care has to be provided. Object clause of the company has to be defined in a holistic manner in the Memorandum of Association of the company. The object clause clearly specifies what the company is intended for, what the company does, and the business nature of the company. The object clause in Memorandum of Association has to be specifically called out and precisely defined. For example, if the company is into business which is beyond territories, doing business in India as well as outside India, the object clause should precisely call out that the business is conducted within India as well as outside India. If the company is intending for a business of export and import, specifically the term for export and import has to be there defined in the object clause. Next is the capital clause. The capital clause specifies what capital is being brought into the company for the business. The capital which is called out in the Memorandum of Association has to come into the company's bank account as capital infusion. So, when we are drafting the capital clause of the company, make sure that the amount comes to the company's bank account after the incorporation. In short, the commitment for the capital has to be within the limits, within the capability of the promoters who are incorporating the company. Next is with regard to the notice specified in the Articles of Association. As per Companies Act, it is mandatory that 21 clear days of prior notice is supposed to be provided for general meetings. There is an advantage for private limited company. As per the notification released by the central government, private limited companies can ignore the requirements of notice of 21 clear days. This is possible only if it is called out specifically in the Articles of Association. Promoters should ensure that such a clause is specifically mentioned in the Articles of Association to avoid future operative issues. The next aspect is with regard to restrictions or limitations for further investments or seeking foreign direct investments. There may be clauses which restrict the promoters seeking further investments. We should ensure that such a clause is not present in the Articles of Association. Next notable pitfall is the shareholding structure when incorporating a company. When there are two promoters who are also the shareholders of the company, they may come up to an agreement incorporating a company with 50-50 shareholding pattern. As we know, every resolution in a private limited company is passed based on the majority. 50 or 51% majority, the resolution is considered passed. When there is a 50-50 shareholding percentage, there is a chance for a deadlock in decisions. When a resolution is put to vote, both the directors, in case one director is for and the other director is against, the resolutions may not get solved. In such cases, there is a concept of casting vote by the chairman. The chairman will be having an extra voting power where the chairman can vote for or against a particular resolution. The promoter or shareholder who is a key person to the company should have more shareholding than the other shareholders. If there are more than 2 shareholders, their shareholding pattern has to be defined in proportionate to their contribution to the company. Companies should not be incorporated with high paid-up capital. The number of shares should always be limited. In case the promoters intend to infuse a higher capital into the company for the operations, the promoters can always do that subsequently with less number of shares and adding premium to it. That way, the number of shares which is going out of the company or getting allotted can be restricted and there can be a proper control by the promoters. The next pitfall is naming of the company. Promoters seldom check into the availability of names before they incorporate a company. Names may be restricted, names may be similar, names may be closely resemblance with an existing company. These have to be precisely checked upon before going for a name availability with the Ministry of Corporate Affairs. The next pitfall or oversight may be ignoring the compliance requirements just after incorporation, such as post-incorporation. There is a requirement for infusing the share capital into the company and filing an e-form INC 20A with the Ministry of Corporate Affairs. This has to be done within the due time. A statutory meeting as per Section 173 of the Companies Act has to be convened within 30 days from the incorporation. Statutory auditor appointment for the company is also crucial just after the incorporation of the company. Auditors have to be appointed within 30 days from the incorporation of the company. E-filings for the statutory auditor appointment has to be done within 15 days from the appointment. Further, the share certificates of the company has to be issued within 60 days. Issuance of the share certificates is followed by the stamping of the share certificates in due time. For this, the compliances under the Stamp Act shall apply. The Companies Act 2013 for the issuance of share certificate and the Stamp Act of the relevant state for stamping the share certificate. As to the recent amendment, Sender's Stamp Act applies to the stamping of share certificates. In short, the compliances of both the statutes have to be harmoniously complied in order to get a proper compliance. The next pitfall is not obtaining the necessary registrations and licenses. For example, a company incorporated to carry on the business of food industry must have an FSSI registration before starting the processes. In case the company is into import or export of items, whether online or offline through customs, import-export code registration is mandatory. In case of software companies or IT consulting companies, Softex registration is mandatory before their sales proceed reaches India. In case the software is exported or the IT consulting services have been rendered and the company is receiving sale proceeds to India, the sales proceed will only be credited into the company's bank account on fulfilling the Softex registration. In case the Softex registration is not present, the company has to go for a compounding of offense with the authorities in order to get the proceeds remitted into the company's bank account. If the company is into e-commerce business or any exporting business, GST registration is mandatory irrespective of the turnover. The next oversight is non-compliant registered address. Never consider your home address to be your business address. Home address or your house are intended for domestic purpose. As per the local laws, maybe your panchayat, municipality or corporation intends domestic address or domestic place be used for domestic purpose only. Your domestic address might be having domestic electricity connection and domestic taxes to the government, whereas businesses have to be conducted on a commercial premises. The commercial premises
will be having a commercial electricity connection as well as commercial taxes are being paid to the government. There are certain documents which has to be submitted to the Ministry of Corporate Affairs with respect to the premises of the business. Having been said so, there is a provision when incorporating a company to provide a communication address. The address can be subsequently changed. Provisions provide for changing the communication address within 30 days with the actual commercial registered address. The next pitfall is overlooking intellectual property aspects. Intellectual property being trademark, copyright, or patent should be reserved and preserved. Parallel to incorporating your company, your unique name has to be trademarked to safeguard your brand name for the future. In case your business stands upon a secret formula or a trade secret, ensure to get it patented before or just right after the incorporation. Any literary work or publication be copyright protected before it is exploited by others. Next pitfall is not having a strong founders agreement. When founders unite together to form a meaningful business, the roles and responsibilities of each founders have to be defined. This have to be in writing and signed by the parties. The roles and responsibilities, the capital infusion, the obligations and rights of the parties, including exit clause, have to be clearly defined in the founders agreement. If these pitfalls are addressed properly when incorporating your company, mark my words, you will have a strong business base.
With this, signing off, Muhammed Riyas.